have to arrive at a decision whether or not a prima facie case has been found against the Chief Justice Gertrude Saki Tokonu following petitions to have her removed. Now, President Mahama has forwarded as many as 3 separate petitions to the Council of State demanding the removal of the Chief Justice. The latest makes 4 petitions submitted for the removal of the Chief Justice. Now, details on the current petitions remain unknown, but we can show you what processes a petition must necessarily go through before the removal of a Chief Justice, one like Chief Justice Gertrude Tokonu. So what are those processes? According to the 1992 Constitution, in order to remove a Chief Justice, now these conditions must be fulfilled. First, the President must have received petitions, and we've told you that so far there have been 4. I'll explain why. At the moment, the President has only forwarded 3 petitions to the Council of State. The President must also consult with the Council of State. Obviously, that's why he's done that as part of the statement that was released from the presidency last night. Now, what will the Council of State be doing? They'll have to determine that there is cause indeed for the case before them. There is cause for the removal of the Chief Justice. Once that is done, when that prima facie case is determined, or if it's not determined, then the petition will then be dismissed. So those are the conditions that will have to be followed in order for the Chief Justice to be removed. Now, so it goes on to also say, and by it I mean the 1992 Constitution, that where a petition has been referred to a committee under this article, the President may, in the case of the Chief Justice, acting in accordance with the advice of the Council of State by warrant signed by him, suspend the Chief Justice when a decision has been taken by the Council of States. Well, we also want to find out, really, have these processes ever gone through before? Remember, Chief Justice Tokonu will not be the only one to have a petition against her. But so what have we seen in the Fourth Republic? Philip Edward Archer, Chief Justice between 1991 and 1995, no record found on him. Isaac Kobina Abba, 1995 to 2001, no record found on him as well. Edward Kwame Redu, who was Chief Justice between 2001, excuse me, I need to get rid of that, 2001 and 2003. Could we see that quickly? I'm going to show you that quickly. Just hang on for me. Should be one of these. Well, there you have it. 2001 and 2003, we know that there was a petition against him by Francis Kwaku Ansa-Asare Kofi. The basis of that petition was that there was some line under oath about his date of birth, whether it was 1934 or 1932. Again, Francis's case against the Chief Justice was that he had perjured himself. He had also deceived Parliament during vetting to extend his tenure and committed perjury by providing false information to a public officer. So that is what we know as far as the petitioner against the Chief Justice Edward Kwame Redu between 2001 and 2003 is concerned. But how did that turn out? That's what we are going to find now. The conclusion of that case was that the petition failed, mostly because Edward Kwame Redu voluntarily retired. And so that petition failed. Again, Kwame Redu will not be the only one to suffer such a fate. Between 2003-2007, Judge Kingsley Akwa, Chief Justice then, was also petitioned against. His removal was sought by Bright Oblite Akwete. The reason for Bright's petition is really simple. Judicial interference. He accused the Chief Justice at the time of instructing judges on how to rule on specific cases. In that, there was an abuse of office, misusing his authority in judicial matters, and victimization of judges who spoke up against him, essentially. That petition, again, woefully failed. We also have Georgina Theodora Wood. This one many of you remember because it's quite recent, 2007 to 2017. there were 2 petitions against Georgina Theodora Wood. Citizens of La Home and abroad petitioned the president at the time to remove Georgina Theodora Wood. The basis for that petition, again, unfair handling of land cases related to the Gadangbe people. We also know that there was the petitioner, Ernest Obri Latte. Basis for that petition was stated misbehavior and incompetence. How did that petition also end? That petition. Right. The last one I wanted to show you was against Chief Justice Sophia Ekufu. That petition was brought against her by Mensa Thompson of ASEPA, and we know that that petition failed. Let's get on to the phone lines now and speak to former director of the Ghana School of Law, Kwaku Ansa-Asare. I appreciate you talking to us, but good afternoon to you. Let's talk about these petitions that, indeed, these 3 petitions that have come up against the Chief Justice. My guess is you are not surprised based on the history we have just detailed to our viewers.
Yes, I'm not surprised. But let me say that the petitions are becoming one too many. They must come to an end. And lots of them are frivolous. So most of them should no longer be entertained to bring an end to the mushrooming of petitions.
I see. I want us to focus particularly on Chief Justice Tokonu, also because this will be the 4th petition against her. Based on history, she will be the only Chief Justice in this 4th Republic to have as many as 4 petitions against her removal. Do you still consider that frivolous?
My sister, it is not the quantity of petitions that should concern us, but the quality of the petitions. In order for the petition to be looked at all by the constitutional bodies or persons mandated to examine such petitions, you need to find out first what the criterion is. If you look at Article 146, Clause 4, where the Chief Justice decides to go into or inquire into a petition, the Constitution says that there must be a prima facie case. So unless a petition raises a prima facie case, it will not be entertained. In the case of the removal of the Chief Justice, the prima facie case element is missing. And this has given some worrying concerns as to whether any petition, regardless of its frivolity, must necessarily, be entertained by the president for onward submission to the Council of State. So let's be cautious, in entertaining the petitions, that are emerging. A lot of them are frivolous and vexatious. I heard you say that one of the petitions against former Chief Justice Georgina Wood, former Chief Justice Kwaku, talked about judicial interference. And in the current case, Tokonu's case, they raised allegations of judicial interference. Do we have the evidence?
I see, lawyer, are you referring to...
Do we have the evidence that any of them...
Lawyer, hold on for me. Lawyer, hold on for me. There are 3 petitions as of now. We do not know the details of those petitions yet. However, we know that under the Akufo-Addo administration, there was a petition. The detail that you have just said about judicial interference being the basis for the petition, are you referring to the Akufo-Addo period petition?
Yes.
Right.
Because that's the matter in hand.
Right, which is where I want us to move on from, right? Because that petition didn't go anywhere. here we are, three more petitions. Do you expect this petition to move beyond the Council of State?
I will not agree with you, in your suggestion that that petition didn't go anywhere. It went very far. It went very, very, very far. Which enables the former president, to make a final determination. Now the question is, in determining the petition that sought to remove the current Chief Justice, I am referring to Kwaku Ansa-Asare petition, did the former president act in accordance with the provisions enshrined in the 1992 Constitution? And, what do I refer to? I'm referring specifically to the processes outlined in Article 146, Clauses 6, 7, 8, 9, and 10. Now, Article 146.6 outlines the procedure. It says that where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. So let us, for the sake of argument, for purpose of argument, suppose that when the former President received the petition, he did all that. Then the question that arises is, because the petition submitted by Kwaku Ansa-Asare was for the removal of the Chief Justice, because of her leadership, did the former President consult? Did the former President consult with the Council of State as mandatorily required by Article 146? If he did, then we move on to, did they set up a committee? Was it in compliance with Article 146? If he did all that, then the next question, the committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office.
Right.
Was any such committee set up? Did the committee that supposedly was set up inquire into the petition? Did they make any recommendation to the President whether the Chief Justice ought to be removed from office or not? How do we get hold of their recommendation?
But again, that is what the current administration or the president of the day is trying to do. That is why it's been forwarded to the Council of State. So the process is being...
What has been forwarded to the Council of State is not, I believe, is not what President Kwaku...
no one has said that.
Submitted to Nana Akufo-Addo, the former president.
Yes, absolutely. Lawyer, follow me. I'm saying that 3 petitions have come up. And the President, John Dramani Mahama, has forwarded those petitions to the Council of State. Now, I only made reference to the petition during the presidency of Nana Dankwa Akufo-Addo. That since that petition did not have any conclusive effect to remove the CJ, do you expect that this one could perhaps have the same effect, or it would indeed result in the removal of the CJ? What are your thoughts? Is there any stated misbehavior that you know at all, as far as the CJ is concerned?
But the President will be wrong in referring any petition, whatsoever, to the Council of State if the earlier petition submitted by Professor Kwaku Ansa-Asare has not been dealt with. If it has not been dealt with, because we all know that that petition, the machinery has been set in motion, for the inquiry to be conducted. If it has not been dealt with, why are we collecting many more petitions, and for what? When we do that, we are turning the whole thing into a political persecution.
No, hang on, lawyer. Can the President reject petitions if they are brought to him?
The President must act in accordance with the Constitution.
And he is, isn't he?
The President cannot override the Constitution. I'm saying that my submission is this, that if if the pending petition has not been dealt with, there is no good reason for the president to collect new petitions and forward same to the Council of State. He must deal with the arrears first before looking at fresh ones.
Very well.
So we have to find out whether Professor request petition was dealt with.
Understood.
Now, if we find out, and it is found out that the former president did not act within the dictates of the 1992 Constitution, then that petition must now be revived. Let them bring it up for the president to act strenuously, rather than be tolerating fresh and fresher petitions.
Indeed.
It's not going to help us.
Very well. Lawyer, thank you so much for talking to us. Kwaku Ansa-Asare,
Welcome.
there for you. Thank you so much.